The Oklahoma State University College of Engineering, Architecture, and Technology presents Ask the Experts, the 4th annual Hazardous Materials and Waste Management Update. And now, here's your host for today's teleconference, Bill Mitchell.
Hello, and welcome to Ask the Experts, a national teleconference from Oklahoma State University in Stillwater, Oklahoma. Our first hour today is dedicated to the Clean Air Act of 1990. Our expert in that area is Randolph L. Jones, Jr. Randy Jones joined the Tulsa law firm of Hall, Estelle, Hardwick, Gable, Golden, and Nelson as a shareholder in 1990. His legal practice principally focuses on environmental, energy regulatory, and international law matters and related litigation and administrative proceedings. Randy's experience has covered a broad spectrum of environmental areas, particularly air, water, and hazardous waste permitting and compliance issues. Now, Randy Jones. Randy?
Thank you, Bill. This morning I've been asked to talk about the Clean Air Act amendments of 1990. I feel like I'm being asked to perform a miracle in some extent, because what took Congress 10 years to formulate and over 2 weeks to negotiate, I've been asked to address in 30 minutes. Obviously, I can't cover 328 pages of statutory material in that time. So what I hope to do this morning is to cover just a short overview of some of the important titles, then address a couple of the titles in a little more detail, and close with some thoughts of my own on what you should be doing at this time in preparation for the upcoming regulations and permitting process. The amendments have added titles to the Act, and as this chart shows, there are really 6 titles to focus on. Title I, Air Pollution Control and Prevention, refers to non-attainment areas. Title II is the Mobile Sources Auto Standards. Title III, General, is really where the hazardous air pollutants have now been covered. Title IV is the acid rain. Title V, Permits. Title VI, Ozone Protection. In addition, I will be touching on the enforcement provisions. The non-attainment amendments call for new classification of non-attainment areas, setting deadlines to achieve attainment on the basis of the severity of present pollution levels. They lay out a full array of control measures to be implemented in non-attainment areas, including tighter controls on industrial plants. The mobile sources in Title II call for a further tightening of emission standards applicable to motor vehicles. The amendments also establish requirements for petroleum companies to come up with clean fuels, such as reformulated gasoline, and for the auto industry to develop vehicles that can burn the clean fuels. Title III Air Toxics set forth a list of 189 hazardous air pollutants and requires EPA to promulgate new control standards for most sources of such emissions. Title IV, pertaining to acid rain, really imposes a new set of requirements primarily on coal-fired power plants, designed to cut national emissions of sulfur dioxide approximately in half, with reductions also required in emissions of nitrogen oxides. Title VI, Ozone Protection, establishes new requirements to restrict emissions of chlorofluorocarbons as a further step toward addressing problems of stratospheric ozone depletion and global warming. Title V, Permit Requirements, calls upon the states to establish comprehensive new permit programs for all significant air emission sources. They also provide for the payment of permit fees by operators of those facilities. Lastly, the enforcement provisions have been greatly strengthened, particularly by adding new criminal sanctions. Title I, pertaining to ozone non-attainment, now classify problem areas as marginal, moderate, serious, severe, or extreme. Deadlines for achieving attainment in the primary ambient air quality standard for ozone are controlled by a sliding scale, which varies from 3 to 20 years, as this chart indicates. The extreme category, 20 years, is for Los Angeles at this time. However, it can be imposed on other regions. Ozone non-attainment, which had previously been addressed almost exclusively through the control of volatile organic compounds, or VOC emissions, now requires some of the more heavily polluted areas to extend requirements for for installation of all reasonably available control technology, RACT, to sources of NOx emissions. The amendments direct EPA to accelerate its efforts to provide generic definitions of RACT for specific industrial categories. This guidance is to be issued in the form of Control Technology Guidelines, or CTGs, rather than through the formal rulemaking process. In an attempt to assure steady progress, all non-attainment areas, other than those classified as marginal, must achieve certain specified increments of progress until the primary standard is met. And the most dramatic changes will impact small business concerns is the modification in the definition of major source, accomplished by lowering the de minimis level in certain areas. Smaller VOC sources are now subject to emission controls, 50 tons per year in areas classified either as moderate or serious, 25 tons per year in areas that are called severe, and 10 tons per year in Los Angeles or other areas which might be classified as extreme. Again, looking at that chart, besides making those changes in the de minimis level, Congress has also changed the offset ratios for each of the areas. For marginal, it's now 1.1 to 1. For moderate, it's 1.15 to 1. For serious, it's 1.2 to 1. For severe, it's 1.3 to 1. And for extreme, it's 1.5 to 1. In addition, if an area fails to comply, EPA is required to impose a 2-for-1 offset reduction. Besides these direct impacts, there could be hidden or indirect impacts of greater concern for new source construction. As the regulators do everything they can to reduce the emissions of VOCs, a likely consequence is that emissions available for use as offsets will dry up. Without a source of offsets, industrial growth will be stifled. In addition, the permitting requirements will likely result in lengthy administrative proceedings to obtain approval. And this impact is not limited to new construction. It will also impact operational changes at existing sources which in the past would not have required a permit. Finally, Title I is not limited to VOCs and NOx. Other non-attainment considerations are carbon monoxide, particulate matter, nitrogen dioxide, sulfur oxides, and lead. Title II pertains to mobile sources, and I will just touch on this shortly. The new act takes a novel approach to mobile source emission reduction, coupling traditional reductions in tailpipe emissions with mandated production of so-called clean motor fuels. Other fuel-related restrictions include limits on volatility and a ban on the availability of leaded fuels for highway use beginning in 1996. The next two charts highlight the statutory schemes applicable to mobile sources. And rather than go through them, I'll just give you a chance to briefly glance at them. With respect to the fleet vehicle regulation, these only apply in areas designated as serious, severe, or extreme, and then they exclude rental, law enforcement, and emergency vehicles. Many of you have heard the term reformulated gasoline. What does it mean? Under the new law, it means a 15% lower emission of VOCs and toxic chemicals by 1995 and a 20 to 25% reduction by the year of 2000. There also will be additional standards for oxygen, benzene, and aromatic levels. In addition, there could be no heavy metals, including lead or manganese. The actual standards still need to be promulgated by EPA. 9 areas must phase in reformulated gasoline between the years 1995 and 2000. However, states are not restricted from instituting these same requirements in cities where ozone non-attainment occurs. The Title III deals with air toxics, and this is an area that's new and is probably going to affect the most people out there. Many businesses and sources that were never impacted or covered by regulations in the past. Title III, in essence, mandates an aggressive approach toward the control of air toxic emissions. The basic approach is to require an initial level of control for all sources of toxic emissions. This level of emission control is to be determined strictly on the basis of available technology rather than any defined risk to the public. Under the 1977 amendments to the Clean Air Act, EPA has successfully regulated only 7 hazardous pollutants. Congress greatly expanded the program by establishing its own list of 189 chemicals for regulation. In the 1990 amendments, Congress selected 3 potential types of hazardous air pollution emissions for regulation. These are routine emission reduction from major sources, routine emission reduction from area sources, and an accidental release prevention program and requirements. With respect to emissions from major sources, EPA is directed to establish a list of major source categories such as chemical plants, oil refineries, steel plants, and other manufacturing entities, which will be subject to regulation. Any source emitting 10 tons per year of a single listed pollutant or a total of 25 tons per year of any combination of listed substances is classified as a major source and thus subject to regulation. So it has nothing to do with the size of your facility. It is strictly based on emissions from that facility. It is estimated that approximately 250 source categories are expected to be subject to the new air toxic standards. Where a source emits more than one regulated air toxic, EPA must consider each pollutant at that site. For each category of source, EPA is to promulgate a standard which requires the installation of maximum achievable control technology, MACT, for each type of source. MACT is generally the best available control technology in use at the cleanest 12% of a source category. New source standards must even be more stringent. These standards can, however, compel a wide range of control measures, including not only the installation of control equipment, but also process changes or the substitution of raw materials, work practices, or operator training or certification. EPA is to issue the MACT rules for over 40 source categories within 2 years. The remainder of the sources must be regulated within 10 years. However, the Act does provide an incentive for existing sources to reduce emissions prior to falling under the regulatory mandate to do so. By voluntarily achieving a 90% emission reduction prior to the issuance of a proposed MACT, existing sources can obtain a 6-year extension of the deadline for implementation of the otherwise applicable MACT. With respect to area source controls, under the Act, area sources are small but numerous sources of air toxics. The Area Source Control Program will utilize the same listed substances as major sources. EPA is to establish area source categories such as dry cleaners, service stations, wood stoves, or small combustion units, just as it will for major sources. The installation of MACT will also be imposed on area sources. Emissions from oil and gas wells and pipeline or compressor stations are excluded from regulations unless they are located within a metropolitan area of more than 1 million population, and then only if EPA determines that the emissions of air toxics present more than a negligible risk to public health. The third area to be regulated are accidental releases. As this chart summarizes a few of the items that you must focus on in this area. Congress is to list as extremely hazardous substances, and EPA is to expand it. Included in this list are such items as hydrogen sulfide, ammonia, and anhydrous ammonia. There will also be an engineering analysis of covered facilities required, and that information will become public information. So as you do your studies and reports, you must realize what is written will be seen by the public and others. And as I always advise people, whenever writing material, any material, you have to assume the public and everyone else will be able to read that, so you should write it accordingly. This does not mean not to do the analysis and the evaluations that are necessary. It just means to be careful how you write the findings. In addition, there'll be regulations to cover accident prevention, detection, corrective action, maintenance, and training. In addition, EPA is authorized to issue and enforce mitigation orders, and there's also created a new chemical safety board to investigate accidents. The Title IV covers acid rain provisions. In addition to its new federal operating permit, each source will receive allowances equal to the permitted emission level. An allowance will, in essence, become a marketable federal permit to emit 1 ton of sulfur dioxide. Where a utility reduces the emissions of a plant below the required level, it will accumulate allowances which can be banked to meet future electricity demand, used at other plants which it owns, or sold to another utility, which would permit the purchaser to increase emissions above the levels in its own initial permit and yet remain in compliance. Many of you have probably seen in recent articles in Environmental Reporter and other environmental publications that EPA is currently struggling with exactly how they will handle that program, and there are many different concepts floating around. It'll be essential that you review it when the proposed regulations come out to determine how the marketing and trading of these allowances could affect your facility. Rather than go through the acid rain provisions, the next chart lists some of these major items. And I believe the same material is in the written material that you were provided. As you can see in Phase 1, Congress, again, they were prone to listing substances and facilities in this act, and they've done so with power plants, listing approximately 111 targeted power plants for 1995 reductions. The emphasis and rewards will be on the use of scrubbers, and as I noted, there will be a complicated system of marketable allowances. In addition, Title IV mandates reduction in NOx emissions at power plants. Title V pertains to the permit requirements. And Congress decided to establish a federal operating permit program for all regulated sources. The new permitting program appears to have been modeled after the NPDES permitting program established under the Clean Water Act. Each state is required to create and submit to EPA for approval a permitting system based on the new statutory requirements and promulgated EPA regulations. The permitting system is to be integrated with the existing state implementation plan system and is to implement the new air toxics requirement and acid rain programs. Funding for the program is to be generated by a fee system. The implementing state agency will be required to collect an amount not less than $25 per ton for each regulated air pollutant except carbon monoxide. If a state elects to impose the minimum $25 per ton figure, the maximum permit fee will be $100,000 because no fees are to be assessed for emissions in excess of 4,000 tons per year. Now note, the $25 per ton is a minimum figure. It is not a maximum figure. The 4,000 tons per year is a statutory limit. EPA is required to promulgate general regulations in 1 year that establish the minimum elements of an approvable state permit program. States are then to develop permitting programs consistent with those regulations. Congress directed that the new permitting programs have to be in effect within 4 years. In the event a state declines to develop an approvable program, EPA is directed to prepare, administer, and fully enforce a permit program in that state. Nearly all sources of significant air emissions must apply for and obtain a permit. Permits are required for any facility defined as a major source, which includes any source emitting more than 100 tons per year and smaller sources located in non-attainment areas. Permits are also required for any source subject to air toxic regulations, i.e., those emitting 10 tons per year of any single air toxic or a combination of 25 tons from the list of air toxics. Any source subject to a new source performance standard will also be subject to permitting. Permit applications must be submitted within 12 months after a state permit program takes effect. If the source submits a timely application, it is allowed to continue operations during the review and issue process. This next chart shows some of the attributes. It's listed as attributes. It'd probably be better saying also detriments of a permit. So you can see the permit compliance is deemed compliance with all applicable provisions of the Act. So there is some safe harbor once you receive a permit. We already talked about fees. Permit violations, not less than $10,000 per day. Permits are to be issued for not more than 5 years. And if they're greater than 3 years, no revision for new regulatory requirements will be imposed on that source. However, at the end of the 5-year period, when you have to get a new permit, obviously you will have to comply with any new regulatory requirements that have been promulgated in the interim. EPA retains a veto power over state issuance permits. There are also citizen petitions for review, but they will not delay the permitting process for issuing the permits. And there's also a small business assistance program to be established. The citizen review of permit issuance. In processing permit applications, state agencies are required to provide opportunities for public comment and hearing. In certain cases, states are also required to give notice to neighboring states. In addition to direct participation in the public comment process, citizens can also intervene by asserting pressure on EPA. Finally, even where EPA does not object to a permit, any person can petition EPA to issue an objection. So that's the reason for my comment earlier about the potential delay and slowness of the permitting process with citizen review and participation. Title VI refers to ozone protection. Rather discuss it, I'm going to simply put another chart up which goes through some of the main aspects of that title. Title VII established the federal enforcement provisions. The new act includes a number of provisions that enhance the enforcement authority of the federal government. In general, the range of civil and criminal penalties for violations of the act have been increased. EPA now has air enforcement authority comparable to that found in other environmental statutes. The act sets criminal fines and penalties for a wide range of violations of the act. Criminal violations of the Clean Air Act provisions have been upgraded from misdemeanors to felonies. Fines for individuals can be up to $250,000 with imprisonment for up to 5 years. Fines for corporations can be up to $500,000 for each violation. These maximum penalties generally are doubled for second and subsequent convictions. Negligent release of air toxics regulated under Title III, which put another person in imminent danger of health or serious bodily injury, will subject the violator to fines and possible imprisonment. Any individual who knowingly releases air toxics which put another person in imminent danger of serious bodily injury is subject to a fine of up to $250,000 per day and 15 years imprisonment. Businesses can be fined up to $1 million per day. In addition, the 1990 amendments provide new authority for EPA to implement a field citation program for minor violations of the Act. In other words, the officials conducting field inspections can write and effect traffic tickets for violations they see on site and impose penalties of up to $5,000 per day for each violation. Finally, in this area, EPA is given the authority to pay an award of up to $10,000 to anyone who provides the agency with information leading to the imposition of civil penalties or criminal convictions. The reward program, more commonly known as the bounty program, may prove to be an excellent outlet for employees discontent with management's environmental affairs or environmental compliance policies. In light of all the rescue and police shows we've seen where they've taken actual experiences, I can now see in the future a television show on I Nailed That Corporation under the bounty program. One of the things to be concerned about is the time frame, and I'm going to briefly show what in the next 2 years Congress has mandated that EPA do. I apologize, it's small and it's not really for the data on it, it's just to give you the indication of the task in front of EPA and in front of all of us. And it'll just go quickly. The main thing is this is done for 1991 and 1992 by month, and each gray area on the left really is a particular title. And as you can see, the list goes on and on. and I've just covered the first 2 years. It's been estimated by Congressman Dingell of Michigan that EPA will have to promulgate 400 regulations to comply with the 1990 amendments. So finally, I would like to just touch on some concerns that you should have. Even though you think it may be anywhere from 2 to 10 years before the regulations and permitting program is applicable to your facility, you should be doing certain things at this time. Basically, you have to look at 3 factors for timing. One is when the program is going to be effective at your facility, but it's imperative that you start immediate efforts to do the necessary planning and analysis. In addition, for enforcement purposes, those penalties and provisions took effect immediately upon enactment of the 1990 amendments. Thus, there is an immediate need to review environmental compliance programs to eliminate violations of existing requirements. Third, for new projects, even though the applicability may be years away, you need to start planning and determining the parameters for project lead times and what changes need to be incorporated because of the new law. The amendment creates a pressing need for industrial facilities to develop a far more detailed inventory of all present emissions and controls. For each source, you need to develop a baseline source data. You need to look at the emission of each regulated pollutant from that source. The pollutants and precursors covered by the National Ambient Air Quality Standards, any of them that are covered by the 189 listed in Title III, the minimum of 100 extremely hazardous air pollutants EPA must identify, and you must try to anticipate what others may be added to the list. Next, to the extent possible, this information should be broken down by specific emissions unit within each facility. You also need to know for each source a detailed summary of what equipment and techniques are currently being used to control its emissions. Finally, for each source, you should evaluate whether it is in compliance with presently applicable requirements. The second item you need to focus on is assessing the likelihood that new controls will be required and the nature of such controls. Every source will need to analyze what specific controls and when should they be anticipated under each of the new regulatory programs. You need to evaluate whether the amendment's non-attainment and air toxic provisions may result in imposition of new controls at each source. Since the amendments require that EPA develop control technique guidelines for 11 source categories and alternative control techniques for other sources of VOCs and NOx, you need to determine if a source is included in any of the targeted categories and the nature of likely controls. You need to identify the source category in which it will be included and determine the ranking of that source category. You also need to evaluate whether to reduce the air toxics by 90% to take advantage of the 6-year exemption from MACT that you could achieve. Third, you need to plan for new permits. It is essential that permit applications incorporate an exhaustive summary of all emissions, since the regulatory entity will require a permit revision for sources to exceed permitted allowed emissions. You must determine if a state program will require new legislation to meet the federal requirements. You must submit a timely and complete permit application, which you cannot do if you don't have the data. This will protect the source from being charged with a violation for not having a permit. You also need to anticipate any future changes in products, raw materials, or production processes at that facility which might alter the emissions and require a permit revision if it is not covered by the initial application and permit. The permit itself, you should try to have it specify equipment or operating practices rather than prescribe numerical ceilings. And you should seek a determination that other provisions to which the source could have been subject are not applicable if they're not covered in the permit. Why do all of the outlined evaluation analysis at this time apply to you if implementation for the most part is years away? Much of the federal and state programs will have to be promulgated. You cannot evaluate proposals if you do not know the effect on your facilities. Because of the prescribed time frames in which action must be taken, public response comment periods might be very short. It will be too late then to try to learn about the source and what the potential impacts are. Above all, one should participate in the legislative and administrative proceedings to implement the new programs. It is your best opportunity to influence the program. It may be your only opportunity. And it is also your best opportunity to ensure that you can comply reasonably and economically with the proposed standards. You probably think, what the heck, it's futile. I cannot make a difference. That is not correct. You can. But first you have to know the impacts on your facilities. Only then can you intelligently assess the potential impacts and the potential impossible or unworkable proposals and develop workable alternatives. What I have found in my 15 years of experience is that most regulatory agencies are receptive to comments that are of the nature what you're proposing is unworkable, but we could do this and it would be workable and still achieve your goals. That's what you should work on at this time for your source and be prepared to work with the regulators to develop that type of program. I think I've probably more than covered the time I was allotted, Bill, and at this time I'll turn it back to you and we can proceed to the questions.
Good, because we have a lot of questions, Randy, so come on over and join us. A lot of people were calling in while you were busy talking and showing us that very valuable information. One of the first questions is, do Title II fleet rules apply to all states and all areas?
No, they don't apply to all states and all areas. They're basically non-attainment areas into three worst categories. And then they only apply to fleets that exclude rental cars, police, and emergency vehicles. And also, you have to look closely at the provisions. There are other exceptions if the vehicles are not centrally fueled.
Okay, next question. Do you believe that all manufacturing plants will have to obtain air permits?
I don't think all manufacturing plants will. But when you look at, if you're in the category dealing with the air toxics, the 189, the emission level is 10 tons. It will cover a number of sources, and more importantly, it will cover a number of sources that at this time have no idea that they may be regulated.
Another question, will EPA or the states have educational programs? This person says, so we will know what we will have to do.
I suspect that there will be workshops and training programs. I think you found in certain other areas that have been difficult. EPA has put on workshops like SARA reporting and other release requirements under CERCLA, and also dealing with hazardous waste. So I think one could anticipate some of those programs. But there's no value to you in the program if you don't know the baseline source data from your own facility.
This question from someone that phrases it this way. He says, I work at a manufacturing plant. What is or what should our first step be? That is, where do I go from here?
Well, I think the first step would be to take an evaluation and inventory of your particular facility, identify all your air emission sources, categorize what you emit, try to quantify and look at the controls, then take that information and start working either with your own environmental people or other consultants in trying to anticipate what impact the Act would have on you and where you have potential concerns.
Do the 1990 amendments address Indian lands, and if they do, how are they treated?
Yes, they do address Indian lands, and basically the administrator of EPA is to make a determination if an Indian reservation or land can be treated the same as a state. If that's the case, then the Indian tribe governing authority will establish its own program. EPA must determine that the state has a governing body and has the ability to regulate this type of a program.
Does the term source refer to the entire facility?
No, you need to be careful with the term source. Many of us think that a steel plant is a source. That is true, that's one definition of a source. But under the 1990 amendments, a source can also be each particular emission point within that steel plant. So if you have, for instance, a refinery or chemical plant, you have leaks of VOCs, that would be a source. And therefore, there's potential for hundreds of sources at a particular plant or manufacturing facility. And again, you need to get a handle on those.
Yeah. Are the non-attainment programs constrained by state boundaries?
No, they are not. In fact, the states have to give notices if they could impact other states. There can be also regional transportation zones set up. There was already one set up from Washington, D.C. to New York to cover interstate problems.
Do the 1990 amendments have any implications for voluntary environmental audits?
I think they do, and it gets into when you do them and what you learn. And now that if you find out you're in violation, what happens to you? Are you then subjected to penalties? I think the main thing Congress tried to say was on an environmental audit, they did not want to discourage them. They put in some language that if you find it and if you reasonably take care of the problem, you would only be subjected to the civil penalties and not criminal penalties. The big problem from an audit is if you find out about violations and then you elect to do nothing whatsoever about it, you may very well have moved from the civil penalty arena to the criminal penalty arena.
Will the more stringent California vehicle emission standards be applied to non-attainment areas in other states?
They can be. They're not mandatory. A state has the option of applying the stricter California standards to a municipality. However, it's on a voluntary basis only in the severely polluted cities or contaminated cities. They cannot impose that the citizens in that city must buy vehicles configured for California. So the states are going to have to develop incentive programs for dealers to sell those vehicles.
I found the bounty program you talked about interesting. Do you think you'll have like environmental bounty hunters going out and trying to check on people and calling in? And will that create a boondoggle? I mean,
well, I think from my experience that it's likely to create, I don't know about a boondoggle, but I do believe there will be people. I think more importantly what one has to look at, and in representing some other clients I've come across this, if you have a person disgruntled with management, environmental and health and safety concerns are usually talked about and discussed at facilities. That's one of the easiest things to just tuck in your back pocket when the supervisor comes to discharge you for some other reason. Right before that, you may have mentioned to somebody, well, I think they're violating the environmental regulations. To set it up is a discharge of a whistleblower. Now, there are many legal standards, and they vary from state to state. I think this is going to create watchdogs within the facility, and there certainly will be citizen groups that see that this is a license to become a public watchdog of facilities. And I think many of us can start to name certain types of facilities where we can expect to see the watchdogs, particularly if you're located in or near urban areas where there's more concern with, everywhere concern, but more people see and smell and feel the effects and then see this is a license to try to change it or even harass it. And you have to remember in the permitting process, it can give them ammunition to delay forever or delay for years getting a permit.
so your advice is to people to start getting in touch with those regulations and regulatory agencies now, before these, way long before these go into effect.
Yes. And my best advice has always been to know the regulations that apply to you and to comply with environmental regulations. In the past, it may not seem to be in vogue, or there was a reluctance. I think most corporations and manufacturing facilities now do that. They realize the regulations are here. These provisions make it clear that they're serious. And at this point in time, the best advice is get a handle on it and start taking the actions necessary to make sure the facility is in compliance. That's the best way to avert citizen problems.
From Fort Sill, Oklahoma, number one question, any exemption for military emissions such as smoke generated from military supplies or operation of aircraft?
Well, in 328 pages, that's one of the type of questions you know you'll get and not have looked at, and I could not answer. The Act on a general basis has some exceptions and some regulations pertaining to federal facilities, but I really do not know the answer to that particular
Controlled burning, such as the stuff used by farmers, is that covered at all?
I don't recall seeing anything controlled burning because the standards are not, the emissions aren't considered large enough. However, it doesn't mean in a particular state or local municipality that there aren't ordinances or regulations controlling open burning.
Okay, I'm going to try to read it, and having never read this question before, from the University of Texas at El Paso. What constitutes accidental release and controls or implemented, I think is the word?
Well, the accidental release, that's one of the areas that still need to be defined, exactly what's going to be accidental. It gets into, did you have any knowledge, or was it reasonable to expect that that type of release might occur, or it simply was unexpected and you had no way of knowing? That's a general answer, but I think it's an area clearly, as the questioner asked, it's one that every facility needs to look at and get a handle when the regulations come out, exactly what an accidental release will be in how their training of their people are in accordance with those regulations.
From the same place, who determines what the MECT, I believe, is at any point in time, and where can they get a copy of confirmation of air emissions, pollutant standards, and that sort of thing?
Okay, the MECT standards are going to be established by EPA principally, and then the states have to implement them. As I indicated, that it's going to take some work and data on the 12% of the cleanest sources. Most times you can contact the EPA regional office in order to obtain information about the pollutants or air emissions. And again, a lot of this information is just not available yet, or may not be detailed to comply with the Act.
I believe we have a telephone question now. Let's go ahead to that. I believe it's from Texas. Go ahead.
Yes. My question is, a city like El Paso that shares a common border with Mexico, how could you regulate or enforce these automotive emissions?
You are only going to be able to regulate those in El Paso or Texas. I should say Texas. I shouldn't assume that it's El Paso. I lived in El Paso a number of years, so whenever anyone talks about those type of problems, I naturally think of El Paso. But I suspect what may happen is also because you can't control all sources in that city, you may have to impose even stricter standards on the vehicles in the border city to try to attain the standards. Again, that's one of those areas that has to be developed, but that would be one way of handling it. I do not recall anything about being able to regulate vehicles coming in and inspect them. I've never looked at it, whether or not in an area like that, the federal government may be able to set up inspection standards for vehicles crossing the border.
Okay, from Hattiesburg, Mississippi, Randy Jones, fugitive emissions portion of the Title III air toxic. What is going to be required concerning fugitive emissions?
I think you're going to find, and that's a point I left out going through my notes, so I'm glad you raised it. You're going to have to look at flanges, pumps, compressors, looking for leaks. I think you can anticipate having to replace caps and seals, so to meet VOC and other fugitive emission standards, I think that definitely will be an area that's going to be tightened up.
From the University of Nebraska, what about Freon used in air conditioners if you are a service person using a service garage?
And I only answered generally because it was not a part of the title I studied in depth, and you can gather from my presentation. But there are provisions in there that deal with Freon used in refrigerant uses and also in servicing unit uses, and it's phased in at a much longer time, the controls, when you're using it for servicing.
Do common solvents used in printing and photo development fall under the toxic umbrella workplace in the home?
I don't think they will, because the emission standards are not going to be large enough. Again, you have to look at what you admit and how they're handled.
Anything else in the 1 minute we have left that you haven't brought up that you want to bring up in this 1 hour?
No, I think that just hit again on, there's a lot of detailed information, but you should not feel overwhelmed with it. And I was looking at it, but try to focus. It's just still, again, I can only say it so many times, but keep re-emphasizing, to understand your facility, get a handle on your facility. Once you know that, you'll see a lot of this falls in place, and then you can progress through and just try to influence the legislative proceedings. You think it won't work? I've done it in the past. Go in and talk with a few changes. Don't tell them how it doesn't work or why you're against it. Just simply say, I think you need to do this to make it workable. Give the change on a blank piece of paper to the regulator. Let them use it. I think you'll be surprised with the results. You may find that a lot more changes are incorporated than you thought possible.
Randy, thank you very much. We appreciate it. Just go ahead and sit there and we'll introduce our next guest. Our next session is dedicated to real estate environmental assessment. Our expert in this area is Walter Shoemate. He is with C.H. Guernsey and Company in Oklahoma City. Walter Shoemate got his degree in electrical engineering in 1973 from Oklahoma State University. He got his law degree from Oklahoma City University School of Law, and he graduated in the upper quarter of the engineering class and the upper third of his law class. Now, Walter Shoemate. Walter?
Thank you, Bill. I appreciate the opportunity to visit with you for a little while regarding real estate environmental assessments. To do this, one really needs to go back and look at the history of some of the earlier environmental enactments. From 1970 through 1976, there were a number of enactments that had definite impact upon environmental assessments. The Clean Air Act, enacted in 1970, Clean Water Act, 1972, the Resource Conservation and Recovery Act, 1976, and the Toxic Substance Control Act of 1976. These acts have a particular place in the scheme of environmental assessments because of their importance under the Superfund Act, the Comprehensive Environmental Responsibility, Compensation, and Liability Act, also known as CERCLA, which was enacted in 1980. For example, under the CERCLA Act, the hazardous substance definition is the same as that referred to under Section 311B2A of the Clean Water Act. The hazardous waste definition is the same as Section 3001 under RCRA. The toxic pollutant definition is the same as Section 307A of the Clean Water Act. The toxic air pollutant definition is the same as Section 112 of the Clean Air Act. And there is also the eminently hazardous chemical substance or mixture definition under Section 7 of TSCA. Now, the reason I mention all of these things is because of the interplay with CERCLA. Let me go back for just a second to the Resource Conservation and Recovery Act, RCRA. This created the cradle-to-grave liability scheme and regulation for present hazardous waste activities. One can prospectively comply with RCRA. The problem under the CERCLA enactment dealt with cleaning up of past waste activities. No amount of current business activity can prevent assertion of CERCLA liability where such liability exists, with two principal exceptions. One involves spill reporting requirements, and the second is the innocent landowner defense. That's a long way of getting around to where we're trying to come to. Now, in 1980, CERCLA was enacted. As a result of this enactment, there was a scheme of liability created in 4 principal areas for past hazardous waste dumping, and it was all created under Section 107A. 107A1 dealt with the liability for owners and operators of real property. 107A2 dealt with the owners and operators of property at the time that the disposal took place. 107A3 dealt with, generally speaking, the generators of the waste, and 107A4 dealt with the transporters of the waste. Now, this is a tremendous area of liability, primarily because when you look at the owners and operators of the real estate as well as the generators and the transporters of the waste, this section has been interpreted as creating joint and several liability among all of those entities. The liability also is strict. That is, that it is there without any assertion of fault on the part of any individual. In 1986, the Sarah Amendment to the Superfund statute was enacted. And in that enactment, Section 107B3 was modified to the extent of creating a definition which allowed for 3 exceptions. 3 exceptions to, or defenses to, this liability. One was the innocent landowner defense, one was the governmental entity defense, and one was the inheritance or bequest defense. Now, the thing that becomes most important about this liability scheme is the nexus or the relationship that one must have to the actual operation of the property. And I would like to read for just a moment a portion of the probably the most expansive case in this area, United States versus Fleet Factors, wherein the 11th Circuit stated that under the standard that they adopted in that case, a secured creditor may incur 107A2 liability, the owner-operator liability, without being an operator by participating in the financial management of the facility to a degree indicating a capacity to influence the corporation's treatment of hazardous waste. It's not necessary for the secured creditor to actually involve itself in the day-to-day operations of the facility in order to be liable. Nor is it necessary for the secured creditor to participate in management decisions relating to hazardous waste. Rather, a secured creditor will be liable if its involvement with the management of the facility is sufficiently broad to support the inference that it could affect hazardous waste disposal decisions if it so chose. This is very, very broad indeed. As a result of this type of pronouncement by the court, the next question would be, how does one go about trying to limit this type of expansive liability? Go back to 107B3, wherein this defense was created. The statute says there shall be no liability for a person who can establish by a preponderance of the evidence that the release of a hazardous substance and the damages resulting therefrom were caused by an act or omission of a third party, or one whose act or omission occurs in connection with a contractual relationship with the defendant. This contractual relationship definition is what was handled under the 86 Sarah Amendment. Contractual relationships include land contracts, deeds, or other instruments transferring title or possession unless the real property on which the facility concerned is located was acquired by the defendant. Here's a key. After the disposal or placement of the hazardous substance at the facility, and one or more of the circumstances described below is also established. Here are the three circumstances. At the time the defendant acquired the facility, the defendant did not know and had no reason to know that any hazardous substance was disposed of at the facility. The innocent landowner defense. The defendant is a governmental entity which acquired the facility by its cheat or through any other involuntary transfer or acquisition or through the exercise of eminent domain authority by purchase or condemnation. The governmental entity defense. The third defense is that the defendant acquired the facility by inheritance or bequest. Ultimately, we're posed with two questions. How can one show that even though the disposal of the hazardous substance took place prior to the acquisition, the defendant who acquired the facility did not know and had no reason to know of any hazardous substance release on the property? Second question. How can a governmental entity acquiring property by involuntary transfer or any entity acquiring property by inheritance or bequest show that all disposal took place prior to the acquisition? The risk of not successfully providing the answer to one of these questions by a preponderance of the evidence may well be liability when the level of operative control necessary under fleet factors is the mere existence of the ability to affect hazardous waste disposal decisions. Therefore, we get to this ultimate issue. I would submit that the answer to the first is theoretically contained in section 10135B of CERCLA, and the answer to the second is pragmatically contained there. Now, in answering that question, the statute specifically says that to establish that a defendant had no reason to know, as provided above, the defendant must have undertaken at the time of acquisition all appropriate inquiry into the previous ownership and uses of the property consistent with good commercial or customary practice in an effort to minimize liability. For purposes of this preceding sentence, the court shall take into account any specialized knowledge or experience on the part of the defendant, the relationship of the purchase price to the value of the property if uncontaminated, commonly known or reasonably ascertainable information about the property, the obviousness of the presence or likely presence of contamination at the property, and the ability to detect contamination by appropriate inspection. Now, what does this mean? How does one really go about determining what is going to be sufficient and adequate to meet this test? Because as a practical matter, what really is going to happen is a question of whether or not the inspection has been sufficient in order to meet this test to create this defense. I'd like to show a few things that can be done. First of all, the historical review of this property. The historical review would include the addressing of the issue of the abstract of title. Now, really, this is simply investigating what the quality of title to this property was, and historically, this would be typically in the area of around 50 years. This is because some contamination may not be known or ascertained over a short period of time. It may take a long period of time for it to become evident. You'd want to survey any platting that might take place. Now, the platting, the property may be rural and there may not be any platting. You'd want to look at topographical maps. You'd want to look at appraisals, real estate appraisals, any types of appraisals. Want to look at aerial photographs. Want to look at the surplus list. Now, this indication would tell you whether or not this property not necessarily had been placed on the National Priority List, Superfund list, but whether it had been considered for placement on the NPL. You'd want to look at a soil survey. Now, typically, a soil survey is, I'm not sure I can get this, maybe I can get part of this on here. Soil survey can be obtained through the USDA Soil Conservation Service. And this soil survey can give you an indication of the types of soils that are on the subject property as well as adjacent properties in the county in which the site you're investigating is located. Finally, you'd want to check with all federal, state, or local agencies under the Freedom of Information Act to determine if there had been any activity on that property or conceivably adjacent properties. In preparing to go on the property, first of all, it seems rather obvious that you'd need to determine the location. You'd need to have gone to the courthouse and either done basically a stand-up title opinion or been given the abstract itself. You would want to go through every one of these elements on this list. Superfund site reviews, soil surveys, basically the same as on the preceding list. Now, the site inspection. Where do you start? The first thing that I would start, obviously, you want to find the name of the individual. You'd want to find the general description of the property. You'd need to find the address, location, legal location. You'd want to go through determining if this property or any adjacent properties have been placed on the NPL, National Priority List. You'd want to find where the nearest surplus site might be, if there would happen to be a surplus site in close proximity. Want to find out such things as whether or not there are any active landfills, any inactive or closed landfills. You'd want to determine the types of water supply that might be present at the location, whether it was the water was supplied by a private well or a central water system. You'd want to review the names of previous owners and operators of the facility, as I mentioned, for a period of 50 years. If the title search is used, you'd want to attach that as an exhibit to your report. For each owner, you'd want to provide information such as the period of ownership and operation, the type of activity or process that had been conducted at the facility, the kinds of waste that had been used and thrown off at the facility, and how the wastes were disposed of. Then you'd want to go through some sort of survey regarding whether or not there had been any zoning in this area. Of course, it may have been rural. You may not be addressing that issue. Then you'd need to go through a record investigation. This investigation would obviously take you to the Environmental Protection Agency, the appropriate region there, and the appropriate state and local agencies, health departments, water departments, to determine if there had been any activity on that property in particular. You'd want to also inquire to see if there had been any notification of the landowner or the person involved by any governmental entity of an intent to file a lawsuit alleging a violation of state or federal environmental laws. These types of things would simply be an indication of whether or not there had been a problem. Again, the objective of a Phase 1 is to try to show that there is no problem with this property. You'd want to be provided with copies of topographic maps, geologic surveys, historical maps, aerial photos. Any information you can get on this property is going to be beneficial. You'd want to describe the current uses of the property, including any manufacturing operations. You'd want to determine what raw materials were utilized, the steps in the manufacturing process, the major non-manufacturing activities, the types estimated in volumes and sources of wastewater and other liquids, the types estimated in volume and sources of solid and hazardous waste generated, and the treatment, recycling, storage, and disposal activities for all of these wastes. You'd want to make inquiry to determine whether operation of the facility required a contemplated construction, dredging, or other land alterations. You'd want to make appropriate inquiry to determine whether operation of the facility required federal or state involvement, which might require environmental impact statements or other permits. You'd want to make appropriate inquiry to determine whether the operation of the facility will affect or impact any threatened or endangered species. You'd want to examine drawings and specifications of the facility to determine whether hazardous substances were used in the construction of the buildings of the facility. Obtain and evaluate copies of any discharge monthly reports submitted within the past 2 years. You'd want to make appropriate inquiry to determine whether any asbestos-containing material is currently at place at the facility. You'd want to determine whether there is anything involving PCBs, polychlorobiphenyls, at that property. You'd also want to touch base with the appropriate utility that might have some ownership of that, of any equipment, be they transformers, capacitors, anything of this nature. You'd also want to check for underground storage tanks. This can be done with the appropriate regulatory agencies. See if there had been any indication of any leakage of these tanks. Make an inquiry regarding radon to determine if there was any problem with radon emission at this location. You'd want to make an inquiry to determine whether there had been any past or present judicial or administrative proceedings or consent orders related to environmental conditions at that facility. You'd want to make inquiry to determine whether any past or current owner or operator of the facility received notice that it may be or potentially might be involved with any response costs, including costs of removal or remediation under CERCLA. Important. Investigate the conditions of the site in person. Don't simply rely upon someone else's statements. Don't rely simply upon telephone. Investigate the condition of adjacent properties in person. This becomes very important because there may be subsurface migration of contaminants from adjacent properties that wouldn't be apparent on the subject property. This can also be discovered through investigation of the subject property when taken into account also the information obtained from the soil survey in determining the porosity of the soil. Determine the relationship of the purchase price to that of the fair market value of uncontaminated property. This is one of the statutory requirements that we must meet. Determine what effect activities on adjacent properties would have on the site in question, especially in light of the geologic investigation. In summary, while you're at the site, you'd want to investigate for asbestos. You'd want to investigate for underground storage tanks. Investigate contaminated soils. See if there's anything in that area that would be obvious as far as a problem that might be raised. Is there any discoloration of the soil? Is there any area in which there is no vegetation growing? These are the types of issues that should be addressed as far as the soil is concerned, and that's why it's very vitally important that you make an on-site inspection. Look for PCB transformers, capacitors, ballasts, things of that nature. Radon is an issue which must be addressed. See if there are any buildings or structures there which might not allow for proper ventilation of this type of material. Hazardous materials or hazardous waste containers. Investigate that. While not necessarily an issue that you would address in the Phase 1 assessment, in a site assessment, it may well be that the assessment will turn into a compliance audit. You may find that the property needs to be aware that there are certainly RECRA and TSCA requirements that they need to meet, which they may or may not be aware that they are meeting or are not meeting. Need to investigate for lead in the drinking water. Look for indoor air pollution problems. Determine if there is an environmental program of management. See if they have met all their requirements as far as the local fire department is concerned. Typically the local fire department will be the entity which would have the emergency procedures that must be in place. And then there may be any number of other areas which, when you get to the property itself, will become obvious that you must investigate. Having said that, Bill, I think I'll turn it over to you.
Well, come right up and join us because we have a long list of questions for you. While you were talking, they were coming in a steady stream, believe me. One of them, Walter, it says here, if real estate audits are looking for environmental contamination or liabilities, why are compliance issues so important?
Well, they can become important because of the relationship that that the facility has in meeting its own statutory obligation. If, for example, you go on a piece of property and you find that there is a compliance problem, then, as Randy has mentioned, there are all sorts of other issues, both civil penalties and criminal penalties, that can crop up, and the owner needs to be aware of these issues so that they won't be in jeopardy of violating those sections.
Next question. It seems the Fleet Factors decision could make obtaining plant expansion funding very difficult. Is there any consideration at the national level on this?
Well, there is some consideration as far as the expanse of the Fleet Factors case. And yet, the interesting thing about Fleet Factors, in my mind, is that it simply addresses an issue which has been part of the common law for many, many years, and that is it reinstitutes this concept of let the buyer beware. Only it's expanding it not only to the area of those that are actually purchasing, but those that would have the security interest in the property, or those that might have any interest in the property. If they're going to lend assets as far as the operation of the facility is concerned, they should be aware of what's taking place on that property.
So, for example, if I have a large company and I want to expand and a city is offering me a large hangar to expand in, I'd better think twice, because if I take that, I'd be liable for everything else.
Well, any entity that is going to lend money is going to be one that should investigate what actually is going to transpire on that facility. If they have the opportunity to raise any issues as far as the disposition of hazardous waste, then under Fleet Factors, they would arguably be liable.
The next question is from somebody that says, I work for a university. Should we require environmental audits before accepting gifts of land? He says this could create other problems for us.
Absolutely. Absolutely. In my mind, whether it's in a university setting, whether it's in a trust setting, regardless of the setting, there is no distinction that's been drawn as far as what may be a basis for that liability. And if the university accepts property which is subsequently found to have been contaminated, then I think that it's very arguable under the statute that if they have any operation and control, if they have the ownership of the property, they're liable. The joint and several provisions would require their concern.
Do you ever sample soil, water, etc. in a Phase 1 environmental audit?
Typically, I would say say typically, I would say the answer would be no. The sampling would take place in an expanded phase 2 type setting. I would certainly point out, though, in the phase 1, if there were a problem, that this is a concern and should be addressed. Also, let me go back for just a moment to an earlier question regarding the compliance aspect. I would, in the phase 1 type audit, I would simply say at that point that there are issues outstanding, there are statutes that must be complied with, and based upon those, you would need to address those to make sure that they are there. I wouldn't make any pronouncement within the audit itself that the entity was in a non-compliant state.
Okay. We have a telephone call now from Kurt at the University of Nebraska. Go ahead.
Could you comment in more depth on your feelings about the appropriate level of inquiry versus the purchase price of a property? Say a small gas station operation that might only be worth $40,000 fair market value. How in-depth should the assessment?
Well, first of all, I would look, and I take it we're in the commercial setting. I would look at the basis for the assessment. Are we talking about a comparable sale type of assessment, as far as when I say assessment, as far as the economic assessment, evaluation, the appraisal? Are we talking about comparable sale? Are we talking about replacement? Are we talking about the economic impact of that property? First of all, look at the method of analysis used in the appraisal. Then, if the method is appropriate, then I would simply see if there was wide disparity between that value of the appraisal and one which, in a similar proximity, area-wise, would have come in at a much higher value, say. If that were the case, then there has been a discounting somewhere for the value of that environmental contamination or some other issue. But I would say that certainly if there's a wide disparity between the actual fair market value and what the fair market value would otherwise be, then it would raise a question in my mind as to why. And if the environmental situation is a possibility, then I would certainly investigate it. Did that answer your question? I hope so.
He's off the line now. It's a long question. Okay, it comes from Amarillo College of Texas. Property within municipal boundaries not owned by the city contains a small lake as residential and commercial properties adjacent. Various times over the years may have weed, contains discarded tires, and was used as an asphalt hot mix for highway paving. Diesel oil was used to clean hot mix trailers and is probably present in the ground. What can city do to bring about cleanup upside short of having to condemn property and assumption of liability?
At that point, if the city does not choose to condemn the property, arguably there would be zoning type of issues which could be raised. Now, under the planning, zoning, and police power of the municipality, the question which ultimately is raised in that area is whether or not there has in fact been a taking sufficient to invoke the Fifth Amendment requirement for just compensation. The city, I think, under its police powers, could certainly find cause to go in and investigate the activities that have taken place on that property. But again, it's going to be an issue of, are they investigating or are they taking? And if they're taking, then it would probably fall into the area of the eminent domain provision.
University of Nebraska, what states in the Midwest require real estate assessment for the transfer of commercial property?
I would simply have to investigate the answer to that one. I don't have that answer off the top of my head. This is a long one, so I'm going to read it first time ever from the University of Texas at El Paso. Are you aware of the ASSE Association of Engine Firms in the Geosciences has published a guideline for Phase 1, and that these guidelines are being used as the basis of good practices by most engineering firms? Does all that make sense? It does. Okay. And in answer to your question, no, I was not aware of it. But let me say that in the, not this session of the Congress, but in the past session of the Congress, there was a bill introduced which would have more specifically addressed the issues of what would be included in a Phase 1 audit. The issue of what's going to be included in a Phase 1 audit really goes to the level of whether or not it's going to be sufficient to get the evidence before the court, and whether or not the court then would issue an instruction or take cognizance of that evidence so as to allow that defense to take place. Whether or not an engineering society has accepted it, certain norms as being appropriate, I'm not sure that that in of itself is going to be dispositive of the issue. I think what is more than likely going to be dispositive is what the norms happen to be in the particular area involved.
Why is geological information so important in a Phase 1 assessment?
Well, the reason that geological information is important is because, first of all, in looking at contamination of property, it can either take place through a vertical migration going down through the surface into the subsurface itself, or it can go through a horizontal migration. Now, in looking at the geology of the property, you can determine, at least initially, you can have an idea, you can have a better feel when you see something on the property, whether there is a strong or very weak likelihood that any contamination might have gone into, let's say, an underlying aquifer. By the same token, if you see activities on adjacent properties that are suspicious, then if you have some idea as to the nature of the soil of the subject property as well as the adjacent properties, then you'll have a better feel for answering the question of whether or not that adjacent property could have in fact contaminated the subject property. The simple fact is that the subject property, the site that you're investigating, may be contaminated, and not because of any activity which took place on the surface of the facility itself. It can be contaminated as a result of activities that took place on adjacent properties.
What type of geological information is available short of drilling monitor wells?
Well, as I mentioned before, you can go to the United States Department of Agriculture's local office, the Soil Conservation Service in each county, and those facilities have soil maps for the counties. They're very good as far as giving you a preliminary concept of the type of soil that is available, both as far as the water types, the climate, virtually every basic type of issue that you'd want to address, short of going through the full soils investigation.
From Hattiesburg, Mississippi, any pending legislative proposals such as H.R. 2787 to define what requirements are with Phase 1 environmental assessment?
As I said, in the last session of Congress, there was a bill proposed, and I will be candid, I do not know if that was reintroduced in this session.
What statutory requirements, this is from the University of Texas at El Paso, are you referring to, and who controls the scope of the assessment?
The statutory requirements as to what is contained in the assessment comes out of the 107B3 definition. Now, the entity that controls that, ultimately, the entity that controls what is going to be contained in the assessment is going to be, it's almost an after-the-fact scenario. It's going to be a determination made by the court. Let me relate it this way. Site assessments in many instances are like attorney's title opinions. You won't have to rely upon it until you're involved in litigation. And when you're in litigation, it's almost going to be to the point that it's too late. Now, what you want to do is make sure that your investigation has been sufficient and adequate enough to withstand the test that might be imposed by the individual judge before whom this investigation, the site assessment, is going to be placed.
How many miles from the site itself should that assessment take place? How far should it extend?
Well, at that point, I think reasonably, and again, you have to use reason in all of these things, I would look probably, depending upon the size of the subject property, I would probably simply drive around the property, look, say, a quarter to a half mile in any one given direction to determine if there was anything that became obvious. On the other hand, if you found through your investigation of the records that, for example, there was an MPL site in close proximity, then I might want to do some investigation, if it's in close proximity, of the character of the subject property between the two.
Talking about that, how many years back in time should the assessment cover?
As far as the title investigation, I typically look 50 years, simply because things that may have occurred many, many years ago, especially in the oil and gas realm, may have contaminated soil. There may be a very slow migration process through the subsurface itself, and the true contamination may take a long time to really present itself.
What historical or beneficial historical information can be gained beyond whether or not contamination has taken place on the subject property?
What historical information can be gained? Well, the primary historical information that I would try to obtain is the type of activity that took place on the property. Was it a manufacturing operation? Was it something that had air type emissions, soil emissions, water emissions, toxic emissions, things of that nature? You may not know by your initial investigation that there has been any activity which would have caused a degradation of the property. Again, what you're trying to do is prove, you're trying to erase all doubts and show that there really has been no problem. But the information that you gain by going through this process is simply going to arm you that much more strongly in trying to show what has or what has not taken place.
Okay, this from Omaha. What liabilities exist for the investigator who performs all the standard investigation but doesn't detect the existing contaminants in the soil and water?
Well, again, what I would suspect is that whether it's the individual investigator, again, when you talk about the individual investigator, I'm assuming you're saying that investigator as a company or a partnership or whatever it might be. We won't get into agency and partnership law. But it's going to be governed by the rule of reason. If there was no reason, if a reasonable person with the same similar circumstance, with the same background of expertise in that area, would not have suspected that it would have been appropriate to perform any additional investigation, then under the rule of reason, I think that there would not be any actionable negligence that could be brought into the issue. On the other hand, if in that surrounding area the level of expertise would have indicated that there should have been additional information gathered before a pronouncement was made, then that might give rise to an action in negligence.
Walter, we thank you very much. It's been an interesting hour. We will now take a short break. We'll be back in 15 minutes. Stay with us. Corporate Vice President for Environmental Affairs at RMT Incorporated. Charles has 25 years' experience in the environmental area. He has a master's in environmental engineering from Clemson University, is formerly head of the South Carolina Water Quality Programs, and formerly EPA Regional Administrator for the Southeast. Charles Dieter.
Thank you, Bill. It's a pleasure for us to be with y'all here today from Stillwater, Oklahoma, where, by the way, we've had quite a bit of stormwater in the last several days. Today, I want to talk about the stormwater permit application requirements. First, I'd like to just cover some of the background of those requirements. On November the 16th of last year, EPA finalized their regulations where the basic requirement is that industry with a point source of stormwater associated with an industrial activity must apply for a National Pollutant Discharge Elimination System permit. That is the NPDES permit. the Clean Water Act of 1972 had set up this NPDES permit program, a very successful program, probably the most successful of all of our environmental programs. That program required permits for industrial and municipal wastewater discharges. To get permits, it had control requirements in it. We just made a lot of progress in controlling the processed wastewaters from industrial and municipal facilities. What we saw as we were doing a good job in improving the discharges from industrial and municipal facilities, that we wasn't covering all the things we needed to be covering. You know, we needed to look at other areas. We still saw impacts from non-point sources, agricultural, urban runoff. We also saw some urban stormwater and some concern about the industrial stormwater discharges. During the 18 years, there had been debate on exactly how to handle stormwater. Various approaches have been tried by EPA, by state agencies. In fact, there are a lot of facilities where stormwater was considered to be somewhat of a problem, who already, would have some controls in terms of the stormwater associated with their facilities. There are guidelines for various industrial categories that now do require stormwater controls. So, there has been some addressing of this. But it was controversial, complex, and again, we had that debate about the requirements and whether we should implement those and how to handle the stormwater. With the passage of the Water Quality Act of 1987, the answer was given to us that you, EPA, you, the states, will have a stormwater control program. There were a couple of concerns in the program and concerns in the legislation that get into how some of the program was evolved, how it was developed. For example, there was a concern about the administrative burden. In the stormwater permitting area, we're conceivably talking about as many NPDES permits as we have already existing, basically double the numbers of NPDES permits. So quite an administrative burden for state government, for EPA, and certainly for the regulated community, the industry and municipalities. By the way, for today's purposes, I'm going to talk primarily about the industrial requirements. There are some requirements on large and medium-sized municipalities. There's also a debate about stormwater as to the extent of the problem. Is it basically by definition, really, stormwater is de minimis in terms of its contamination, or level of contamination. If it was highly contaminated, it wouldn't be stormwater, quite candidly. It wouldn't be processed water. So there was concern about spending resources for that type of control. Another aspect of it was, again, our overall putting our priorities to those areas where we had the greatest problem. The program that was developed as a result of the legislation, those concerns, the historical development, was set up to try to address the type concerns expressed. It tried to, for example, give people options to minimize the administrative burden. It tried to look at various measures of combining processes and programs. So, we could help not only the people doing the permit writing, but also the regulated community. One of the things I think came out of that, and it's what you might expect from that process of trying to tailor the program, we saw quite a bit of complexity written into the program and options. For that reason, I think it's critically important that industry at this point in time make sure that they select the best option for them in their application process. With that background, let me just talk to you about some of the things that we will cover in our presentation today. Certainly the key thing is, items like who has to apply, some of the application options we're going to get into. We're going to talk about some of the deadlines, some of the various requirements, and I'm going to touch on some of the things in the requirements that we have found in our work over the country that have been particularly complicated, even troublesome for the regulated community. We're going to talk, in that area, we'll talk about some of the monitoring requirements, how you monitor stormwater, which is a very difficult thing to do. We're going to talk about some of the certification requirements in the application. And the one thing I want to emphasize as I get into our presentation, that in talking with the environmental protection officials around the country and talking with state officials around the country, we're seeing somewhat different, sometimes significant difference in how they're going to approach the program, what their strategy is, and what impact you have. So I would say that in a number of cases, when questions arise, it's important to contact the regulatory agencies involved to see how they're addressing it. What I'd like to do now is go to some of the slides we have that pretty well give you the background of the program and some of the things that we would like to present to you today. This is on the permit application process. I want to emphasize that for the most part, we're going to be talking about the application process itself. The next slide is a key slide, and basically defines what has to be done. And if you are a point source discharge of stormwater associated with industrial activity, you must apply for an NPDES, or National Pollutant Discharge Elimination System permit. There's some key definitions in that sentence that are important to put this whole program into context. First thing is how you define a point source. A point source is a discernible, confined, and discrete conveyance. Important in terms of whether it applies to you or not. What EPA is doing in the point source program is they said they intend to interpret a point source as conservatively as they can. That is, if for discharges historically that may have not been under the old NPDES permit program, you may see those now fall into the point source category. A point source, a clear point source, would be something like a pipe, a discharge pipe. A ditch would be a point source. But when you get into the stormwater area, a point source could be something such as a man-made swale with a runoff. I tend to use a definition myself is if you can see the stormwater discharging in a confined area during a storm event, then you've got a point source. In the next slide, we're going to talk about the various industrial categories that are involved. There's manufacturing industrial categories. There are two categories there. I'm not going to go into the details in the presentation today, but basically in one category, if you've got material exposed, it's assumed that it's come into contact with stormwater. And another category such as textile, pulp and paper, for example, unless the materials external are exposed to stormwater, then you don't have to apply. Other categories that these regulations apply to include mineral oil and natural gas industries, TSD facilities, those are treatment, storage, disposal facilities in the hazardous waste area, landfills. In the landfills, I'll mention that those apply both to operating landfills and to closed landfills. In addition to, after the landfills, the other categories that we will be looking at are recycling facilities, steam generation, transportation facilities, sewage treatment plants over 1 million gallons per day, and construction activities. In the next slide, we're going to look at some of the actual activities. I mentioned a point source discharge associated with an industrial activity. The slide here shows the industrial activities we're talking about. And gosh, that includes almost everything. It includes industrial plant yards. It includes rail access roads. It includes material handling sites, refuge sites, sites used for application or disposal of processed wastewaters, sites used for the storage and maintenance of material handling equipment, storage areas, including tank farms. On tank farms, I think that's important. It certainly could be important in this section of the country, but the water associated with control systems around tank farms, secondary containment areas, for example, is required, the discharge water out of that is required to have a permit. The next category that we are getting into from our slide would be the tank farm, the shipping, receiving areas I want to mention, because just about every facility that you run into has a shipping and receiving area. In fact, a lot of people we've talked to said, I don't believe the requirements apply to me. You know, everything is pretty much within an enclosed building, but the fact that they've got shipping and receiving from their facility, and their facilities in those industrial categories, throws them into the program. And a couple of areas I'll mention that are not, where the things do not apply, and those would be parking lots, for example. You do not, and I'd mentioned, emphasize, you do not have to apply if for discharge from a parking lot, unless later on that's combined with the, from an industrial area. You also, administrative buildings, stormwater associated with them, that is not applicable. Let me talk next about the application process and some of the application deadlines. And for this, I'm going to use the overhead we have here. And this gives you really the application process and what you're faced with. It covers the application, the type of application itself, and the due dates. Basically, you have three types of application. You can have an individual application, you can have a group application, you can have a notice of intent to be covered by a general permit. So I mentioned earlier about the options you could have to make the process easier. Given those options, sometimes I think it's complicated our selection process at the front end. Group application really is one that the agency and others have pushed in the context that you could, if where appropriate, you could group a lot of people together that have similar activities, similar type discharges, similar approaches, and bottom line, similar type stormwater into various groups, and you could have one group application. From that, you could have one, group permit, or in some cases, there may be individual permits out of some of those groups, or pulled out of some of those groups. But basically, that would ease the burden on the people being applying, and also the regulatory agencies. Going back to our overhead here, it covers the various types of application forms themselves. In the individual, you've got to submit a Form 1 and a Form 2F. I'm not going to get into the forms in detail, but except to say that the Form 1 consists of some general information. 2F is a very detailed application form, and it covers quite a bit of information concerning the facility itself. One of the things you run into in the stormwater program is the form and the monitoring requirements really are more extensive than the previous process wastewater discharge permit application forms. Going over on the individual to the due date, the initial date that that application was due was November the 18th of 1991. There is a proposed regulation to modify that until May the 18th of 1992. I would expect that last date, that May 18th date, which is proposed now, will be the one that will be implemented. The group applications come in two parts. Part one has to do with just a bunch of general information, why the group fits together, what the application is, something about some of the individual sites. That is due, and there has been an extension on that. That's due, the part one is due September the 30th of 1991. That's an extension from the previous date, which was actually March, was what the initial group had to be in. Part two of that application is due May the 18th of 1992. Let me mention something about that. The initial EPA proposal had in it a process where you would submit your part one, and then it would be reviewed by the Office of Water, EPA Washington. That process and then there was going to be a year to submit the Part 2. Please note that under the revisions to that regulation, the Part 2, that is the completed group application, has to be in by May the 18th of 1992. And that's going to be quite difficult in that stormwater monitoring is not like regular monitoring. Regular monitoring, you know, you can, when you're ready to go, you can go out and sample. Stormwater, you obviously got to monitor under certain regulated storm events. The last type is the notice of intent. That's a notice of intent to be covered by a general permit. That is not applicable in many states. It has to do with whether a state has a general permit or not. The application will be varied. I think it could go from something as simple as general information on the facility to a complete application. Basically, it looks like you're going to have about 180 days to submit that complete application or notice of intent after the general permit has been developed. Let's go next to some of the testing requirements, or actually the storm event in our slide. Talk about some of the monitoring requirements you're going to run into. I'm not going through great detail on the stormwater monitoring events, except to say, to re-emphasize what I said earlier, that you have got certain type of storm events. You've got a greater than a tenth of an inch. There has to be some distance, 72 hours from the previous event. There's a requirement on monitoring that you get a first flush sample within 30 minutes or as soon as you can as practical afterwards. There's requirements on flow measuring and actually estimating flow and compositing samples. There's some discussion you have to give on the date, duration, and magnitude of the storm event. Bottom line on the storm monitoring is a storm event, the monitoring. The next slide will include some of the testing requirements. We can see that under the testing requirements, and by the way, under a stormwater application, you only got to test by law one time. In contrast to some application, you know, some of you, unless you're certain you've got a representative type of test, might want to do more often, but you've only got to do it one time. Going back to the slide, it shows some of the type of parameters you'd be looking at. For example, you've got to test for the effluent guidelines for your industrial category. You've got to look at what we call the NPDES processed wastewater pollutants. That would be the pollutants in your existing NPDES permit. You've got to test for conventional pollutants, which are things like, I won't go through the list, but things like BOD and COD, oil and grease, total kill-off nitrogen, the type things that are conventional in nature. Another thing that's a difficult one, item two, is you've got to analyze or check for any known contaminants that you would have in your discharge, which means you've got to make a judgment call on those type of materials. So that pretty well covers the type of testing requirements and some of the storm events that you get into. I want to go now and just show you two overheads that talk about two other type categories, one of which very few people, and I'm afraid not everybody's aware of, is an industrial discharge to a municipal system. If you are an industrial facility and if you discharge into a medium or large municipal facility, and that is a separate system, that is there's a separation between the stormwater and the sanitary wastewater in the municipal system, you have got to notify that, or you should have notified by May the 15th, that large or medium municipal system that you discharged into it. That notification is under the third item there. It includes the name of the facility, the contact person, the description of the facility, and the existing permit number. One of the things that we have been concerned about, we have tried to put out information to people that we work with, is the fact that a lot of people have not been aware of that requirement that they should have reported to large and municipal facilities if they had industrial stormwater going into their facilities. Let me give you some examples. In Oklahoma, for example, the Tulsa, Oklahoma City would be applicable cities that meet this, what I'll call the large and medium-sized facilities. Another overhead we have has to do with the application requirements for construction activity, another special category of stormwater. If you have a construction activity associated with these industrial practices where you disturb more than 5 acres of a site, you've got to provide information concerning the location, the area, the proposed measures to control pollutants, the estimate of the runoff coefficients, the name of receiving waters, and submit an application 90 days before the construction begins. Again, those two categories, those two areas, not some that are as well known or well addressed as others have been. A couple of final points I'd like to make in terms of things you should be thinking about, looking at as you develop your process. Similar to some of our earlier speakers this morning, there are things you can do, things you can think about, things you need to be working on in terms of what you can do. The obvious thing, I think the first thing we look at is, are there ways to minimize the number of point sources I have? Can I minimize the point sources? That takes care of a lot of problems in terms of points of compliance, monitoring requirements, things like that. There are some cases where you might be able to group some discharges. There are some areas where we would need to, you could sample after a lot of the discharges go together. Talk briefly about the type permits you can expect out of this program. I expect the permits basically to cover something like what we've seen in some of the SPCC, the oil spill programs, prevention programs, or under best management programs. A program where we look at source control, where we look at stormwater pollution prevention plans. We've got to avoid end-of-pipe treatment. I tell you, if you end up having to treat stormwater just based on the magnitude of it, if you have to treat it, you're in trouble. You need to look at source control, things you can do to prevent pollution. Another thing we need to be doing is doing our analysis and sampling now, because those dates we have are pretty tight. And again, we just don't have that many storm events that are suitable for sampling. Very difficult to actually plan some of those. With that, I just want to say I appreciate the chance to be here with you, and it certainly is a program that you need to be looking at the process, deciding on what to do, and moving ahead with the selected procedure. Bill?
Charles, come on over and join us in the hot seat here. Make yourself comfortable. Thank you very much. I have a bunch of questions. First one, can I simplify my testing? For example, can I eliminate certain materials because I don't have them on my site?
Going back to the testing requirements, would depend on the site. You've got to meet the requirement for testing the general categories that I mentioned, which is the BOD, the COD, the 8 general categories. You've got to test for anything in your effluent guidelines category. You've got to test for anything that is in an existing NPDES permit. The thing that I think you run into in terms of how much additional testing you need would apply to things like what is known in the discharge, what a known concentration of the discharge. That is a difficult area, somewhat of a troublesome area, in terms of what to sample for. So you got to do those. The thing you can do, though, I think is important to minimize the amount of testing and also your regulatory requirements, exposure, points of compliance, is to try to combine as many points as you can. Another approach you could have, if you have similar discharges or discharges from similar areas, you can say these particular discharges are similar, and so therefore the analysis on one is representative of the analysis on the other.
For the typical small manufacturing plant, it seems the general permit is the way to go. Do you agree? And since the general permit requirements are not yet out, this guy wants to know if he's taking a chance to wait and go for the general. I
think the general permit approach is the way to go. arguably what's going to happen with the general permit. One of the things I did not mention in our presentation is a national general permit has been held up in a dispute between OMB, Office of Management Budget, and the Environmental Protection Agency. That the national general permit has been held up because of that. I would hope that permit is going to be released, but it just makes sense for a lot of industries and different categories to group together. For example, in the southeast, the textile industry has got a general permit. A lot of mining operations are going with not a general permit, a group application, a group application. A lot of the mining operations are going with a group application. So I think that is the way to go. And in fact, the irony of the process that we're in is the regulatory entities have really pushed for that, because it makes the burden easier on them and easier on the applicant too.
Once I get a permit, this person asked, will there be any monitoring requirements?
Yeah, there will be monitoring requirements. I'll tell you this, I think the permit limits and the monitoring requirements are going to be much less onerous once you get a permit than they are in the application form. For example, I don't see you having to monitor for all the things we talked about in the application form. I see that you're going to have to, once you get a permit, put in a stormwater pollution prevention plan. I don't see a lot of listing of monitoring requirements. One thing I will mention is certainly applicable to this section of the country is one of the proposals made by EPA is in the oil and gas industry, they not have to do all the monitoring, but just have an engineer certify that they are in compliance with their stormwater prevention plan. So there was some things in there to try to ease the burden, but it's still a significant burden in the process.
Has or will the EPA delay the deadline for Part 2 of Group A permit applications?
Part 2 of the group permit, I think they ought to. I talked with the EPA contractor on that issue early on this week. I think with the amount of work there and with the need to go with the group, I think that it ought to be done. But I'll tell you, their position now is they have not and they are not. But those positions change.
Yeah. Have they changed the deadlines for individual permits?
It's proposed to change. As I mentioned in the presentation, that they have proposed to change that deadline until next year, and I think that will in fact be finalized.
This from the University of Texas at El Paso. Does it make sense to ask municipalities in semi-arid environments to comply, and why?
I think it does. Now, let me give you, I'm not familiar with, I know we got an active audience in El Paso today, and they've had some good questions. Let me give you an example of a town that I'm familiar with, Sacramento, California. They have, I'm not from there, but they have only, let's say, 10 or 15 inches of rain a year. It happens during a very short period of time. Really, when you have big rain events during short periods of time, it's when you get big discharges of pollutants that you don't, where you would have, let's say, a town like Seattle, where you have sort of a continuous discharge. So I think it is going to be applied that way.
This from Omaha. Does the law require that the verification of stormwater discharges be done by a registered VE?
I'm not sure I understand that question on the verification. Let me answer what I think that question may be addressing. The application does require that the signator to the application verify that what he is applying for is only stormwater. And I'll tell you that's a good question, and that's a pretty tough thing to certify to. You know, what you've got to do is determine that that particular facility, that what's going out that discharge, either through testing or your knowledge of the facility, you're certain that's only stormwater. And you have to certify in the application, the person signing the application, you've got to certify to that. The other thing on engineer certification is I would expect the stormwater pollution prevention plans that look to be a part of the permits now to be issued are going to require an engineer certification, a submission by a professional engineer.
When you say the testing is only required one time, do you mean just once during the life of the permit, or once per storm, or once per year?
Once for the application process. You have to apply one time for the application process. Once you get a permit, it's going to vary. You know, I think it's going to vary depending on the extent or the scope of what the regulatory agencies may perceive the problem to be. But I think quarterly or yearly type of monitoring is about what you're going to see.
How can I limit the number of discharge points in my facility?
How can you limit the number? Well, some you can combine. You know, you can do some piping from one discharge area to another. One of the first thing we do when we go out and look at a site is we go out there and we see if we can't get a point below all the discharges. Let's say you got 4 or 5 different discharges within a industrial complex. We see if we can't find a point below all of those. So one, you got only sample that location. 2, you got only that point of compliance. The downside of that goes back to the point I made earlier. You got a potential there for contamination, you know, where it's not associated with stormwater. Another thing you got to watch out in sample points is, do you have a neighbor upstream who may be contributing stormwater that's going through your facility, and pick that up. Industrial parks, for example, very complicated in terms of requirements, and there are provisions in the law, that, in the regulations, that allow you really to go in and to have a joint type application covering that type facility.
If I submit a group application, what type of permit will I get?
Well, if you submit a group application, the way the system is set up now, you're probably going to get a general permit covering that group. But it is conceivable that you might have some individual permits. People might pull some of the group out. One thing on the group application I would go back and mention is when you're looking at a group and when you're deciding on joining a group, look carefully at the other members of the group to make sure that you're comfortable that what you do and what they do are compatible. You don't want to get in a group where you may be, that they may have a lot of problems, you may not have very many, for example.
From Milwaukee, this question, the definition on medium or large municipal facility: when an industrial facility discharges stormwater to the municipal facility, which municipal facilities are exempt, and is that based on size, for example, population?
Could you give me that question again? Is it the...
Define medium, he's asking for a definition really,
okay,
on medium or large municipal facility. When an industrial facility discharges stormwaters to the municipal facility. And then he asks, I guess the second question is, which municipal facilities are exempt, and is that based on size, population?
It's based on size, and the specific municipalities that are included in small and large are in the Federal Register. The November Federal Register that I mentioned, 1990, has a list of those municipalities in the country, small and large, that are covered. And so they are defined in that regulation.
Here's another one of those long questions. It's going to take me a minute to get through. This is from our good friends in El Paso. With regard to affected industries, the EPA included SIC codes 10 through 14, which they say includes natural gas transmission facilities that are not identified with these SIC codes. Natural gas transmission is under SIC code 4922. Thus, where do natural gas transmission facilities fall under? Was this a mistake by the EPA, and if so, please clarify.
I don't know. I'll tell you what, I'll look at that question during the break, and I just don't know the answer to that.
But we'll get to it.
We'll try.
We'll try.
Well, in fact, we will. We'll get to it.
Good. How will the recent Office of Management budget hold on portions of the stormwater regulations impact on the program?
I think one of the impacts is that I mentioned the 3 application options you have, and one was a notice of intent to be covered by that general permit. The problem you run into is if that general permit is going to be held up by OMB, you know, how are you going to submit a notice of intent to be covered by it? I would hope that EPA and OMB can resolve their differences so that we clear up that issue of how or whether you can apply for a notice of intent to be covered by that permit when it's still being held by the Office of Management and Budget. Now, I'll tell you, I've had 2 determinations or 2 discussions in various regions of the country on that point, And one region of the country says they wouldn't accept an application until that, to be covered by that permit until it's released. Another state that has the authority has told me that they would accept a notice of intent to be covered by that, and they feel like the industry has met their responsibility. It's up to the government to meet their responsibility. So you see differences, and I think that is a clear difference in terms of how people interpret that requirement.
And then people would ask the question, which application option for me? How would they know?
Well, I think of the options, if you are fairly small, if you fit logically into a group, if you've got trade associations or things like that that have got a group together, I think that is clearly the way to go.
Okay, we have a call now. Go ahead, caller.
On rental property, is the industrial renter or the property owner responsible for obtaining the rainwater runoff permit?
I think the question was the property owner or the renter responsible for the stormwater associated with that facility? If that was a question, in most cases, the industrial activity itself is going to be responsible.
Okay, thank you.
Do we have another call? No, not another call. I have one other question here. What conditions or limits do you expect in the permits issued under this program?
I think the one thing we're going to see is a lot of management plans. We're going to have the stormwater pollution prevention planning process. Another thing that could, you could run into is a few other limits on different pollutants. One of the things that the new national general permit, the one being held up by OMB, has in it is a toxicity testing requirement using what we call, they're using a cereodaphnia. What that is, a small water flea. It's a toxicity testing requirement. And that is a difficult test to meet. I'd say that when that particular permit, it'll have to go out to notice in public meetings, people ought to look at that toxicity testing requirement and comment on the advisability of it. I personally, professionally believe that's a test that, because of the uncertainty of it and the lack of control on it, is not a good test of whether a discharge is really toxic or not. But that's in the permit.
Charles, we thank you very much.
Appreciate being here.
You bet. He will be back a little bit later with everybody else when we have a final panel. It is now about 20 minutes after the hour. We will break for 30 minutes for lunch. We'll be back at 12:50. That's Oklahoma time. Back to Ask the Experts. This is session 4, mixed waste. Our expert for this session is Donald Rash, an environmental engineer with the Department of Energy, Idaho Operations Office. Donald?
Thanks, Bill. I hope everybody had a nice lunch, and we're ready to talk on a very easy subject for us at the Department of Energy, and for everybody else it may sound somewhat confusing and not really something that's well known outside of the Energy and EPA, the regulatory agencies, and NRC. Mixed waste basically and realistically is simply a mixture of hazardous waste and radioactive waste. We look at who regulates these things. We have the Nuclear Regulatory Commission, which regulates the radioactive portion of this, and they look at the generally commercial use of radioactive materials. DOE is a self-regulating entity in the use of radioactive materials, and primarily we use it in either research or in the area of weapons manufacturing. And lastly is EPA, which regulates the hazardous portion along with the states and various air NESHAPs type radiation implementation. Now to break this down, we're going to break it down into two components, the radioactive component and then into the hazardous waste component. And we'll do that by looking at how radioactive waste or radioactive materials are regulated or where they fall in. What we have here is a view graph showing the different regulations, different laws, and different statutes that regulate radioactive materials. The first one is low-level radioactive waste, and radioactive low-level waste is generally defined negatively as all radioactive waste other than high-level waste, transuranic waste, spent nuclear fuel, or uranium and thorium tailings. In other words, low-level waste is really byproduct material, which is not uranium or thorium mill tailings. Byproduct material, which is identified in 42 U.S.C. 2014 E1 and 2 is looked at as radioactive material that has been yielded in or made radioactive by exposure to radiation incidents to the process of producing or utilizing special nuclear materials. Again, this excludes uranium and thorium tailings. The next area is spent nuclear fuel. Spent fuel by itself is really not a waste, it's a material. So we're looking at a fuel that has been irradiated in a nuclear reactor, withdrawn, and by itself is not a waste but is a spent material, followed by the high-level waste. And high-level waste is defined as the radioactive, the reprocessing of spent nuclear fuels. The next one, D on the chart, transuranic waste, I couldn't find a Pacific U.S. code identifying a definition for this, but it is really the alpha-emitting transuranic isotopes with half-lives of 20 years or greater and containing more than 100 nanocuries per gram of waste. Transuranic isotopes are those isotopes with an atomic number greater than uranium. Next, we fall under on the chart to source materials. Source materials is your uranium and thorium materials or any combination thereof, including ores. The mining of ores that have uranium or thorium or a combination of those in a 0.5% by weight or greater is considered a source material. Following that, we come into the next item on the chart would be your special nuclear materials. Special nuclear materials